Now, Joanna, one of the things that was so spectacular about the last year was the CCF's presence at the Supreme Court. We actually appeared at the Supreme Court 4 times in that year. We're scheduled to appear at least 3 times in the new year. So big presence for an organization as small as ours with some incredible legal counsel representing us. Why don't you tell us about some of those cases we were involved in last year? Let's start with a case that was just argued about federalism and a case from Quebec and the question of whether or not a province can be forced to implement federal law.
Yeah, so that was an interesting case. It's a Ministry of Justice for the Attorney General for Canada versus Ministry of Attorney General for Quebec. And as you say, it was really, it concerned a specific Indigenous Child Services program that the federal government was asking Quebec to implement. But the issue that we took with it and the issue in the case didn't have to do with the program per se. It had to do with the fact that you had the federal executive directing, even you could say coercing the provincial government to implement a program without any type of consultation. And just as this case was going to be argued, this became all of a sudden like a very relevant zeitgeisty case in the context of how we look at the division of powers. Because I didn't really understand this before, but it's a popular misconception that the federal government is somehow preeminent over provincial governments. That's not how the federation is designed to be set up at all. They are sort of co-equal and sovereign in their spheres of jurisdiction. And so the federal government can't say, well, we're the feds, we're Ottawa, so go do this. And as Danielle Smith and her Sovereignty Act brought that out, and we're not going to get into that because we're not involved in any litigation around that right now.
Yet.
Yet, it's coming. But I think the point is that, the federal executive can't just can't just deputize the provincial executive to do what it wants to do. It has to consult with it. It has to see it as an equal partner.
What stood out to me about that case, the federalism in Quebec case, was it's so interesting that Quebec is saying to the feds, we don't have to implement federal law. You can't you can't coerce us into implementing federal law. And that case got, I would say, very little attention. But when Alberta says the same thing, you can't force us to implement federal law, it is a huge thing. Now, there's constitutional issues with the Alberta Sovereignty Act as well, but there's a thread that runs through these issues where Quebec doesn't receive the same level of scrutiny, some might say, that Alberta does.
Maybe we're just used to it with Quebec.
Yeah, you lived in Quebec. You went to school there, so you're more familiar with the unique culture of that province. But let's move on to another case, one that's actually been decided by the court now that the CCF had a big influence in, and that's the Annapolis case from Nova Scotia, decided by the Supreme Court, that dealt with something called constructive taking. And we've got a minute and a half or so. What can you tell us about that case and the CCF's impact?
So Annapolis owned a huge, valuable parcel of land in Halifax. The city decided to essentially promote that parcel of land, bring all this bureaucratic red tape so they couldn't develop it, promote the land as a public park while not acknowledging that they were effectively taking it, doing what in law is called a constructive taking. Previously, the law had been basically, you need an ownership right in order to get compensated in that circumstance.
Yeah, because governments can expropriate property, but they need to pay compensation. In this case, if you just take it and act like it's yours and sort of restrict the owner's ability to use it, they didn't pay compensation.
Yeah. So the good news is that we got an amazing result which clarified that no, there doesn't have to be a transfer of ownership right. If the government uses your land and gets an advantage from it, then they have to pay compensation. And it was a 5-4 decision. It was very close, but it was also clear that our submissions were pivotal, if that's not too immodest to say. It's a huge case, and it's huge for property rights in Canada,
which are not constitutionally enshrined in Canada, but do have common law protections.
Yes.
Now, we've got about 30 seconds. We're heading to the Supreme Court a few times in 2023. What are those cases, just briefly? I know there's the Impact Assessment Act. What's that referred to as?
So that's called the No More Pipelines Bill, and that essentially says that the government can't just use what's called the incidental effects doctrine, which is to say that if a federal area of jurisdiction spills over into the province, they can just use that to fully legislate. And we say that goes too far. They can't just go into provincial areas of jurisdiction and take over.
And there's also the question of, does the charter apply to Indigenous self-governments, which has never before been considered, and we're hoping to get leave in our case about patient choice in healthcare.